Well, so
Speaking.
Hello.
Okay. I want to welcome everyone to today's meeting of the Medical Cannabis Policy Advisory Board. We are here in Salt Lake City. Excited to get started. We'll go ahead and start with the introduction script. This meeting is being held virtually and is hosted by the Utah Department of Health and Human Services Center for Medical Cannabis based in Salt Lake City, Utah. Public notice of this meeting was provided as required under Utah's open meeting laws and was posted on the Utah Public Notice website. In compliance with Utah's open meetings law, this meeting is being recorded. A recording of this meeting will be posted to the Utah Public Notice website no later than 3 business days following the date of this meeting. A rough draft copy of the unapproved written minutes will be posted to the Public Notice website within 30 days of this meeting. Approved minutes will be posted to the Utah Public Notice website no later than 3 business days after board approval. Every proposed agenda item must have a 1-page summary of the topic submitted to MCPAB at utah.gov no later than 7 days prior to the board meeting. Board members will present the 1-page summary during board meetings, and board members will discuss the summary. If no written summary is provided to board staff, relevant agenda item will be removed from the agenda. Only items that have been submitted in writing in advance of board meetings will be allowed during discussion by the board chair, including presentations from the public. Board members will then request additional presentation and memorandums on those agenda items and from relevant bodies to be presented at the next board meeting. Those presentations and memos will also need to be submitted to MCPAB at utah.gov 7 days prior to the board meeting. For public comment instructions, public comments will be limited to 2 minutes per person. If you want more time, you must request it from the chair. The chair may accept or reject requests for additional time. A public comment period is not guaranteed every meeting. The chair has the authority to create and remove public comment period from the agenda or during the meeting. You can look over public comment guidelines that are posted on the Utah Public Notice website. Please state your name and your affiliation when making a public comment so it can be reflected in the meeting minutes. Only comments made on items listed in the agenda will be considered. If you have a comment about an item not listed on the agenda, please email them to mcpab@utah.gov. For those listening via Zoom, the Zoom public chat has been disabled during the meeting. When the chair indicates it is time for public comments, you will use the raise hand icon on Zoom to indicate that you would like to make a comment. When you are called on, you will be taken off mute. Take 2 minutes to make your comment. For those present in the room, please sign the public comment sign-in sheet with your name and indicate that the agenda item that you would like to make comment on. The chair will indicate when it is time for public comment period. The board chair will call on you when it's your turn and you will come to the public comment table. Take 2 minutes to make your comment. As a reminder, if you're in person, please do not speak when others are presenting. Our mics are very sensitive and those attending over Zoom cannot hear when there is more than 1 person talking at a time. Side conversations and comments from the public during this board meeting are prohibited. Please use a voice that is louder than your typical one when speaking, commenting, or presenting. When you speak, please lean towards the table as if there is a microphone. For additional information, to make comment, to make a suggestion for agenda items, or to contact board members or staff, send an email to mcpab@utah.gov. I'll go ahead and move on to the approval for November's meeting minutes.
I move to approve. I second.
Perfect. No one else add anything before. All right, we've got approval. Please show a void. All those in favor of approval? Aye. Sounded unanimous. Those present. We'll move on to administrative business. I know one item that was mentioned is that during the same time of our meeting next in January, is scheduling. Let me just have Rich explain it since he knows exactly what it is.
Yeah, so University of Utah is hosting a symposium. University of Utah Center for Medical Cannabis Research. There's a few individuals that are involved with this board who plan on attending, such as Misty Smith. And so we wanted to see if there's a possibility that we could move the meeting to a different day that would work better for the group. And we also want to encourage any board members that are interested to go, if they're able to that meeting to be able to learn more about what's being done in the research landscape by researchers in Utah. And it goes from 8 a.m. to 4 p.m. I think. So it's a full day meeting. So we don't have to decide now what day, but it seems that that should be something that should be adjusted.
Okay. I mean, is there my thought is, I mean, if we do move it, can we move it back one day? I know last time we tried to move a meeting, it was quite difficult. To kind of get everyone on, so I mean, it has to be, if you need to be remote, that is perfectly fine. We can move earlier on and a little bit a week. All Trevor and Abby probably just send out a few different times. So that we can get it in, we'll get it out, and then by the time we get the agenda, the time is scheduled, if that's okay.
The only issue with doing it one day earlier is that's Martin Luther King Day. I don't know if that matters to anyone else, but.
It does for
It's not-
state holiday.
Wednesday, day after.
Wednesday would be
Okay.
perfectly reasonable. Yep.
Yeah, that would work better for us too.
Yep.
Right, yeah, so we'll just work on that in our strategy meeting, just find, we'll get the time before then.
Yeah, perfect.
So, I mean, okay. Other than that, there's not any other administrative business. We'll go ahead and just move this thing along, and we'll go right into an update from the Department of Health and Human Services. And Rich, you have the floor.
Great. Okay, so I'll just share a few statistics that the board may be interested in and the public may be interested in hearing about. As of November 30th, 2024, there are 91,794 medical cannabis patient card holders who have active medical cannabis cards. And we now project, based on the current numbers, the trend, that we should hit 100,000 patient card holders in April. So we can plan on seeing that as a milestone in our program. The growth rate and the total number of medical cannabis card holders, just so you know, was about 30% last year. And this year we plan on it being between 32 and 33% growth. So there's higher percentage growth this year than there was in 2023. Slightly bigger growth percentage there. Okay, so that's medical cannabis patient card holders. And then we have 955 qualified medical providers registered in the program, and then 79 pharmacy medical providers or pharmacists that work in the medical cannabis pharmacies. Also, there's an email that we sent to all of the DOPL licensed MDs, DOs, APRNs, and PAs and podiatrists that provided some new resources that we have. And we've talked about these resources in the past, but just so everybody knows, we sent them a link to the new videos that University of Utah created that provide information about how to talk to your pharmacists about medical cannabis at a medical cannabis pharmacy. Also, how to talk to your medical provider about medical cannabis if you're initiating that with your medical provider. And there's also a video that's specifically for new medical providers who are just learning about the program. So we included that in our email. Also, there was a link to the new patient assessment checklist that we talked about previously that's on our website now. And so it just guides medical providers about how to screen their patients if their patients are asking about medical cannabis. And so that was, there's about 36,000 medical providers that was sent to. It's just a basic email that had that information. Also, it had a link to the list of the medical providers on our website who have given us permission to post their contact information on our website, who are QMPs. And this is just part of the legislature's requirement that we do educate medical providers about medical cannabis in the state. And so we felt like that was an important step to take when those new resources were created by the University of Utah and by us with help from the Center for Medical, or with help from the Cannabis Research Review Board, is who helped us with the patient assessment checklist. So we thought that the board would be interested to hear about that. We'll follow this up with emails that we're sending out to all of the pharmacy medical providers, and also just to the medical cannabis pharmacies to let them know about the email that we sent to medical providers, so they can kind of see the context in which we were sending it to them. And we'll send it to other stakeholders as well, physician groups, associations, so they can see, hey, we sent these all to medical providers. You're welcome to follow up with medical providers about the email as well.
Rich, is it possible for us to get the copy of that email as well?
Yeah.
I've not seen those videos, actually, it's looking for that. I'd like to get.
Yeah, and I can have Abby just send you a link to the videos as well after this meeting. And then, yeah. And then if you have any questions or feedback about the videos, of course, share those with us and we can pass them on to the University of Utah. But Dr. Matt McKiff was featured in one, and there was a pharmacist from one of the medical cannabis pharmacies. Actually, there's two different pharmacists from different medical cannabis pharmacies who are featured in those. And one thing we encourage the businesses and advocates and stakeholders to do is, in your own channels, share those resources. We want to make sure they just don't sit on our website, obviously. So that was one of the reasons why we shared the email and blasted it out to all these DACA licensees, is we felt like it doesn't do any good just sitting on the website, right? We want to make sure it gets some traction and use. So that is an update about what we're doing to educate medical providers and stakeholders about the medical cannabis program. Just a few upcoming events is we have a medical cannabis provider quarterly meeting on Thursday, January 9th. This is a meeting that we invite all medical providers registered in our program, all the QMPs to attend, and also the PMPs, the pharmacy medical providers attend, and then representatives of various medical clinics that do a lot of recommending of medical cannabis. And at this meeting, on the agenda is going to be the new administrative rule that by that time will be effective. And we've talked about that. That rule establishes the standards for targeted marketing engaged in by medical providers and medical clinics. And we'll also include a discussion about, or we'll do some training on the limited medical provider certificate entering. We noticed there's a need to just share some reminders about how that's done. So we're going to be covering that topic as well. And then also we did create a website that's dedicated to that meeting. So the minutes from previous meetings with medical providers is available to the public and to any medical provider that may have missed the meeting. So that's on our website. And if anyone is interested in on how to get there, it's just under the providers tab, and then you go to the quarterly meeting under that, and then you're able to view what those minutes were. And there's links within the minutes to some of the documents that we referred to during that meeting. But of course, QMPs are an important part of our program, and we just wanted to make sure we strengthened our relationship and education with them during these quarterly meetings. So we had the first one in October, and that went well. And so the next one is, like I said, on January 9th. And then legislative session begins on Tuesday, January 21. And that lasts for 45 days, so it ends March 7th. And then also later in, I guess also on January 21 is the University of Utah Center for Medical Cannabis Research Symposium on Tuesday, January 21. The registration deadline is Friday, January 10. And the U of U will be hosting 2 keynote speakers, and both of which have made some contributions to medical cannabis research and some of the national conversations that have happened about that. Ryan Bandry, he's a professor for Johns Hopkins University, and then also Rosalie Liccardo-Pacula from University of Southern California. So they'll both be there presenting the keynote at that event. And then the Cannabis Research Review Board meeting has been rescheduled from January to February. And in case you're interested, at that meeting, there'll be some discussion about the PTSD guidance document. And then also there'll be a presentation on current research on cannabis for the treatment of epilepsy. Will be one of the topics covered at that. That's on February 11th instead of January. That's all.
Thank you. So I don't have any questions. I think Rich. Right, we'll move right on to the Department of Agriculture and Food. Dr. Forsyth.
Thank you. I believe Cody is joining online today. He just got back from Vegas, where he was attending his son's rodeo activities down there. So happy for him. Sorry if we're a little bit behind on emails to anybody that's expecting one from Cody. He's still getting back into the swing of things and came back a little bit sick from Vegas, unfortunately. So we'll excuse him attending in person here today. If you ever get a chance to look at his son's performance, it was quite miraculous down there. All right. So we have the closed door pharmacy rule that was filed. JD kindly pointed out to us that there was an error in the filing. The wrong draft got sent, but we're still intent on the draft that was submitted to you guys to be the one that goes into effect. So don't be too concerned there. We'll get it all straightened out here in the next couple of days. We have the Establishment Licensing Board meeting happening tomorrow at the Taylorsville campus. All the licensees that will be participating there should be notified and will be attending tomorrow to have their licenses considered for the next year.
By chance, it's gonna be downstairs, like it's in the past, upstairs, or in your building. It's the same, it's the same actual.
2507, so in our building,
In your building.
Yep.
Okay.
in that center conference room. And then just wanted to bring something to you guys' attention as the board. We've been getting a number of complaints, and also some of our inspectors have noticed powdery mildew in facilities. This has been going on for a while. Just for reference, one of our inspectors has noted it several times over the past couple of months. And we've received 5 complaints total in 2024, just to give you some context about how big of a problem it is from patients and also workers at some of the facilities. Just so that you guys are aware, we don't see a direct harm to patients from the powdery mildew, or we can't show that there's going to be direct harm to patients. So it's not something that we're acting on, but we want the board to be aware of that. And if you guys would like us to take action on that, it would be something that you could suggest to us to take action. But we don't have any plans currently unless it becomes a bigger problem.
I just have a quick question, if I could, really quick. Is it like several facilities?
Yeah, it's not a single facility.
And is it
noted.
just processors, or is it?
No, it's generally a cultivation, but we have seen it at processors as well in packaged flower. And generally, this is one of those things that almost kind of takes care of itself, because obviously the people packaging this flower don't want it to be there. They don't, it hurts their brand image. And so when they get a complaint about it, they have to recall that, or return that product to the pharmacy. So it is kind of a self-limiting thing anyway. That's why we're not overly concerned about it, but we certainly don't like to see it in the market either. But at the same time, we don't think any of the licensees want to see it there either. It's just sometimes it slips through production.
Are your inspectors, when we notice it in a facility, commenting to the licensee?
I'm not aware. It's not the inspectors, it's the sampling technician. Sorry if I misspoke. So when they're collecting samples, they might be mentioning it. They don't always talk to the people who are in charge of the facility, though. They're usually talking with somebody that's just over the inventory that day. So they bring it back to us. And then we've begun engaging with a group up at the University of Utah to perform the market analysis for this following, or for this outgoing year. It's likely going to be a little bit later this year. We're probably not going to have it published until April, just because we are trying to do a little bit more thorough job this year and work with the group that has some experience in doing these kind of analyses and get a lot more data specifically from the Utah market so that we can make sure it's directly applicable and actionable information that we have. And unless there's any question, that's it for us.
Another question, is Cody Sunny in Cooper?
Yeah. You'll probably see a picture of him in his fur coat.
In his fur coat. Seriously, he's got a fur coat, he wears it.
It was a joke.
Oh, okay.
It's not.
I did have one question, Brad.
Yeah.
This has been a couple of meetings ago, but we were talking about, the process of targeted marketing, right? And the department at that time was taking the position that a website was considered advertising, even if you kind of put the same guardrails that pharmacies did around it, right? Age gated it, you require them to consent to receive, information. Is the department still taking that same position? Or is the department of the mind that targeted marketing through a website with an age gate, with a consent, is actually targeted marketing, not advertising? This that is going to impact how we log, you know what I mean, and look to make changes around advertising. Because if it's considered advertising, then that's a whole different game for operators. If it's considered targeted marketing, which I believe is what this board recommended. So we just never gotten an answer, and you all spoke in that meeting a few months ago, and you had said you would provide us with an answer as to why you thought one way or the other, and obviously we're a month out from the session. So if we could get an answer on that, that would be helpful, because that's going to dictate probably, discussions around advertising abilities, and if something actually needs to be changed in the code or, or not. So we appreciate the answer.
Yeah, so the answer to that is that we really aren't trying to force one viewpoint or the other. We're just trying to get clarification from the legislature as to what they want to have happen. I don't have a preference one way or the other myself. I just would like the legislature to clarify so that we can enforce properly.
But if there's a difference between advertising and there's a difference between targeted marketing.
Oh, so you're asking for a
yes,
definition?
Yes, we're asking for you guys to tell us, what your interpretation is. Because the way I look at and read the law and the way I interpreted the recommendation that led to that portion of, targeted marketing for processors being put into the law was based on the recommendation from this board that said exactly that. They could have a website as long as it was age gated and had, appropriate consent, just like a pharmacy does. And then they could engage in the same types of targeted marketing, short of wasn't recommending discounts, incentives, and anything around pricing. We can look back at whatever our recommendation was, but we just want to know what the department's position is. Because seemingly from the meeting, prior meetings, it has been that having a website at all would be considered advertising. And as we know, if it's advertising, you're very much limited. If it's targeted marketing, you have greater, abilities. And the rule that you all, put out didn't clarify it one way or another. I get that you may want clarity from the legislature, but we just want to know what the department's position is. I personally want to know what the department's position is. And I think they appreciate it as well.
I'm not prepared to address it at this time.
I just flagged.
If Cody is, he can raise his hand and give it to us, but otherwise we can get back to you on it.
He raised his hand.
Cody?
Here we go. Can you guys hear me now?
We can.
Right. Now I know why we hear that every meeting, because it is a little bit of a pain to get on here, to raise your hand. So the reason the department's asking for clarification on that is it goes back to 4-41A 403 in the statute that says that cannabis production establishment may maintain a website that contains information about the establishment and employees and does not advertise any medical cannabis and cannabis products or medical cannabis devices. And so to JD's point, there is that portion about target marketing now that allows for some stuff, but it does seem to us that it's in conflict with what I just read, 403.3. And so that's why we're asking for clarification on that. We would rather it just go away, which I think is what's going to happen, what we'd like it to do. And so we don't want to do anything that's in conflict with the statute, obviously. So.
Thank you, Cody.
Yep.
Before do you have anything else to add, or?
No, that's it.
Thank you for your time. We'll just move right along to the next item. We do have the presenter here in the room. If you want to come up, Mr. Russell. So the next one is with something we talked about last month, is the cannabis use by participants in problem solving courts. We did receive an amended rule change. And we'll go ahead and just kind of turn the time over to you.
Thank you, friends. I didn't know if you would have me speak to this or not. I took up so much of your time last time. I'll be brief. At the last meeting in November, I appreciated your attention and your thoughtful suggestions. This has actually helped us in our process by meeting with you. So I hope you know that we're grateful for your input and perspective. The materials hopefully have a color copy of the revised proposal that is an attempt to specifically incorporate what we talked about last time. So as a reminder, there is statute 78A 231 that has two subsections currently. One says treat medical cannabis the same as any other lawfully prescribed controlled substance. And subsection 3 of that same statute says that a court in this instance is not in a position to require an individual to abstain from the use of medical cannabis so long as it's lawfully being done in any probation agreement or term of probation or clean abeyance or diversion, etc. And in the problem solving court context, the treatment court context, it's been challenging because we're really micromanaging a lot of what's going on in the person's life in terms of their personal conduct, where they go, what they do, how often they're coming to court, testing, compliance with treatment regimens, and that in that particular instance, there are some challenges with not having the ability to require a person to abstain. The proposal before you has a new draft subsection 4 and subsection 5. Subsection 4 would say that if the treatment provider determines that the use of medical cannabis is a barrier to the person's progress in the treatment court program, that they could require the person to abstain from continuing to use that substance while they're participating in the problem-solving court. But importantly, and as feedback from you all, and I agree it's completely right that this be there, that can only happen after consulting with or attempting to consult with the qualified medical provider who recommended the medical cannabis in the first place. And I have learned that that's the best practice for all medications. Anyway, I think I may have said that last time, but it was an error to not include that in our initial proposal. I'm grateful that that's been brought to our attention. There's an additional change at line 39, you'll see, which is that the individual, in order to require that they abstain, there has to be the individualized determination that it's a barrier, but then also that the individual was informed before entering that program that they may be required to abstain. And that needs to be consistent with subsection 2 of this statute, which says the court's going to treat this the same as any other lawfully prescribed controlled substance. So we need to be telling people that across the board, and medical cannabis should be no exception to that. If you're in this program, treatment providers may make treatment modifications, therapeutic adjustments to your treatment regimen that may require you to use this substance and not that substance if you're going to continue in the program and continue advancing in treatment. The final addition is this subsection 5, which would say that the Judicial Council, which is the governing body for the judiciary on administrative matters, it would be required to establish rules that require the collection of information. How many people enter into a program with a valid medical cannabis card? Of those people, how many are required, is the determination made, and how many are required to abstain? And so that we can know the true impact that this is having. This this proposal, without any effort on my part, came to the attention of the USAVE committee that Department of Health and Human Services is also responsible for. And they met, I think, on the 10th of this month and had a discussion about this. And during that presentation, a judge who runs a problem-solving court indicated that adult felony drug court indicated that in the 3 years that she's been running her court, there have been 2 or 3 individuals who where there was a medical cannabis issue, right? Where they came into the program with the card and so she anecdotally indicated that she didn't believe it was going to be a vast number of people that this affects. Even so, tracking the data will give us an ability to be accountable and to report back upon request any of the underlying data so that people can continue to assess the utility of this and the impact of this if the proposal were to be put through. So that's the changes that have occurred since the last meeting in November. I'm happy to answer questions. Otherwise, I'll stay out of your way and let you do your deliberative process.
I appreciate it. One question I had on here is the change we've added here. It says after consulting or attempting to consult. I mean, what's it's slightly vague. My concern is that if just an attempt is made and you're not getting a hold of that recommending medical provider, that a lot of patients using medical cannabis have done so to get away from traditional opioids or other medication that maybe this affects from. And so it may be more detrimental. And so that recommending medical provider understands that background with that patient. So I mean, is it just a one and done attempt? Or what's the thought behind this as far as just attempting to consult?
Yeah, great question. I appreciate that. Thank you so much. So the idea is that failure to be able to make contact with the qualified medical provider ultimately shouldn't allow for the medical cannabis to continue to be a barrier for that individual in progressing in their treatment program, in this judicially managed treatment program. It would need to be a good faith attempt, though. It can't be like I went outside my office and I called out into the world. It has to be the sort of effort that is good faith attempt to consult, right? I'm happy to see different language there. Ultimately, though, because of the way in which these individuals' progress in the program may be contingent on dealing with this issue, and in light of the fact that we may not always be able to get a response back from a qualified medical provider, we wanted to have some language that allowed for progress to continue to be made. Maybe a corollary in the medical cannabis statute should say that a qualified medical provider who receives outreach from a treatment court shall, as part of being a medical provider who's making these recommendations, make good faith efforts also to respond to efforts to consult, right? Either way, we want it to be good faith. We want it to be a legitimate effort. We aren't trying to sidestep. And if this language passed, I would go around the state talking to each of these programs saying, this is what the statute is going to require of you, and you better not cut any corners on it. Because people's medical, I don't need to preach to you. These are medical decisions that affect people's treatment, and it can't be done casually.
So if the contact cannot be made, who then makes the decision whether or not the participant is required to abstain? Would that be the judge, or would they allow that participant, provided they have a valid medical cannabis card, to continue to use that substance during the
if it's determined to be a barrier and they can make contact with the qualified medical provider, there's a discussion about the therapeutic benefit given all the realities of the person's life outside the program and also their progress in the program. If they can't make contact after attempting to consult, then the treatment provider, a medically trained appropriate individual at the treatment provider, would ultimately be able to make a determination. And it would be the court who would not decide it, but would enforce compliance with the treatment plan outlined by the treatment provider. So it would still be a medical decision, not made by the judge, but made by a qualified individual.
With the judicial council making rules and then requiring the collection of those, last thing is just like who had one, how many were taken, who was allowed or who was not. to use medical cannabis during their treatment, how would we go about finding those numbers out? They collect it, does it go automatically to the Department of Health? Do they have to report it somewhere? Like.
It wouldn't be required to be reported at any particular place. Great question. We would collect the data and then it is publicly, or not publicly available, but it is government information. And so it would be subject to records requests and also sharing of government records. Any information would likely be, not likely, would be de-identified from the patient to protect their, because there wouldn't be a release for that. But the numbers would be available, absolutely.
With grammar request, basically.
Exactly. And we've filled requests like that all the time that are not outlined as a requirement for us to provide in statute because it's government information. It's not owned by us and should be shared if appropriate.
Couple of thoughts. If we were to include the language about the failed attempt, I think minimally there should be an effort to collect the data on how many of these failed attempts actually impact the ultimate decision. If you're tracking some of these other data points in item number 5, perhaps 5D could be to ascertain the number of failed attempts or lack of responses from qualified medical providers. So we can ascertain how much that is impacting outcomes. My second thought reading this is, I still don't I don't understand how the problem solving court works statewide, or if there could be an opportunity for more treatment providers to become qualified medical providers, because that seems like that would address some of the concerns with not being able to reach a qualified medical provider. And if that's something that could maybe be incentivized somehow, I think that's something that should be looked into.
I appreciate the feedback. I just have a few thoughts on it if you're interested. Otherwise,
Yeah, absolutely.
thank you. Don't want to presume that you want to know what I think about it, but many of the individuals who are providing treatment within the treatment court context are working under grant funds from the federal government. And even though I think this is my interpretation, I'm sure people might disagree with me in some instances, even though I, as a grant funded treatment provider, can provide treatment to an individual who's using medical cannabis, I can't actively be recommending that medical cannabis to them and still be compliant with federal grant requirements, which say explicitly you cannot use federal grant money and then use it to recommend or promote the use of medical cannabis. And so I think within those confines, it would be difficult to align that. The other thing that came to my attention from the meeting last time, as well as speaking with Michelle McComber at the Utah Medical Association, is the importance of not disrupting the patient and recommending provider relationship and saying, well, now you're in our program, we're going to substitute the person you had been going to for this person inside the program who's now your qualified provider, and will make these decisions, partly because there's a fee associated with it. I think Desiree, maybe you pointed that out last time, or somebody here did, and partly because that's an individual person's choice about who they're going to get their medical care from. And so I think it would be nice, though, to have, we talked about this a little bit, we never settled on a solution. It would be nice to have a qualified medical provider outside the program, but who is maybe under contract, available to be the person to consult with in the event that the actual qualified medical provider is non-responsive to attempts to consult. But again, that's us substituting our judgment for that individual. Like we're swapping doctors on them unilaterally without them having input, and that may be disruptive to that patient-doctor relationship.
Yeah, and if I could add just something to keep in mind under that scenario is, how is the visit with that QMP that's designated by the state charged? Right? I mean, they have to be paid somehow for their work. Is it just something that the DHHS covers, or is it something that board covers, or the patient covers? That gets a little complicated about who's going to cover that cost. We do contract with the medical provider to help us with education, and we consult with that medical provider on issues beyond education, on education materials and things like that. And he's, also the chair of the or he's the prior chair of the Cannabis Research Review Board and in the QMP that does training as well. So if we were to go that direction, I think the thing to figure out would be how is the cost addressed for that visit? Yeah.
One thought too that occurs to me is, again, we're not to diminish the importance of each individual patient, but we're talking about a relatively small number of people in the grand scheme of things, I think initially. And as we look at these numbers after a year, I think we'll know pretty clearly how frequently we fail to be able to make contact with QMPs. And if it's a real problem, I think there's some solutions that could be explored as kind of a second step in this process down the road. We may find that qualified medical providers are very willing to consult and advocate for their patient and make sure that the information is understood before determinations.
We spoke with that judge that person said that they had 3 folks come through their, through their drug court. Were any of those 3 asked to abstain from cannabis as part of their participation?
I believe that in their application process, they voluntarily chose not to in order to better their chances of getting into that program. The problem that a lot of people find themselves up against when they're facing such serious criminal offenses is they're likely going to go to prison if they're sentenced, and they can't use medical cannabis in prison. So it's kind of a challenging catch-22 for the patient. They can either not take advantage of the program and face an increased likelihood of going to prison and then not be able to use medical cannabis, or they can voluntarily elect not to use medical cannabis to avoid prison and participate in the program. Either way, medical cannabis isn't an option for that subset of individuals. Unless in certain instances, it's not a barrier, like in the mental health court, it is often a barrier because of the way in which substances interact. But in the Veterans Treatment Court, as I understand it, it is not often seen as a barrier, and in fact is permissible so long as you don't run afoul of some of the VA type restrictions and regulations. So each circumstance is going to be different, but I personally hate the idea of somebody being in the hard spot of having to say, do I let go of my medical cannabis to participate in treatment, or do I not let go of it, but then face a heightened likelihood of going to prison where I can't use my medical cannabis? It's challenging.
So what I hear you saying is that people are voluntarily choosing to do this if they think that's what's best for them to be able to maybe get in the program or stay in the program. Why not just stick with something like that? Allow people to voluntarily decide. Because I think our public policy on this is clear. I think when we read the statute up above, I mean, it to me includes every different type: probation, release, plea and abeyance, agreement, diversion agreement, or a tendered admission. I think those are pretty well covers the gamut of the types of conditions that can be imposed on someone. So I do think the legislature thought this completely through. And if you're saying that people are already voluntarily making that decision, why not do that?
Yeah.
I think that's one question. And then I think my other thing is that this idea of attempting to consult, I could very easily see it being a single phone call, and that's it, that's all. And someone who you are saying likely doesn't have experience with medical cannabis, likely isn't, recommending medical cannabis, is now going to be that decision maker. So what I think would be more prudent is if we are to recommend this, to remove that attempting to consult language. You all gather data on that for a year. If that becomes a barrier after a year, if that seems to be very problematic, then I think you can come back and go back to the legislature and ask them to put that language in there. Because I do see that as being a single phone call. And as you know, even when you're a patient calling a doctor's office, I don't think I've ever been actually allowed to talk to my doctor over the phone. About as close as I get as an assistant, and that's rare. It's usually the person at the front desk. So those would be some of my thoughts. And again, I won't reiterate what I said the last time, but I will say that I do believe public policy is clear on this. I do believe those that fought for the rights of medical cannabis patients in Utah and the lawmakers who put that into law were very thoughtful on this. And I do think they thought of these scenarios. And cannabis is to be treated like any other controlled substance. And what that is saying is in a proceeding, this is talking about an adjudication. In an adjudication, you cannot abridge the rights of medical cannabis patients. And so I, again, just disagree with the interpretation of the two. But really going back to, the questions that I have is, if patients are already making these decisions on their own to be a part of this program, and they're willing to give that right up to not have to go to prison or to be a part of the program, I think that should be considered. And then just the idea of whether you'd be amenable to removing the idea of attempting to consult until you can collect some data on it.
Thanks, JD. I appreciate that feedback. On the voluntary issue, it works out really great. And statute isn't at issue if the court's not requiring the person to abstain when the person says, okay, I voluntarily won't use it, and they come into the program. But they say they want to voluntarily pick it back up while they're in the program because it was a voluntary choice on the outset. And now they say, well, I changed my mind. I'm going to start using it again. Now the court can't require them to abstain and they're in the program. So what do we do at that point? How do you enforce program requirements that are contingent on the person voluntarily saying, well, I'll do it. And if I don't, you can't do anything about it. That's part of the challenge. And we don't want to do an end run around the intent of the statute, which is that judges are not to require people to abstain, including enforcing terms and conditions that will punish a person for voluntarily choosing to use something that statute says they should be able to. So that's part of the challenge. But I hear where you're coming from on that. I would like to get, I think judges would like to get to a place where in good faith, they can say, we're applying the statute with fidelity. We do it under these limited circumstances. Here's the stringent criteria that we follow in order to disrupt this. And by the way, it does in fact treat it identically to all of the other lawfully prescribed substances. And so they can then be compliant with subsection 2 and 3 by having subsection 4. On the actual consultation, I think that that's a reasonable thing to require. Now, what we may end up finding is that there are some QMPs that won't respond even with our best efforts. And I don't want it to devolve to a single phone call. I gave your take there. I think your proposal to require consultation feels a lot more tenable to me if there's a requirement on the QMP to respond. A legal statutory requirement that if you're going to be a QMP and you get outreach from a program, they're required to consult with you, QMP. QMP, you are required then to be a receiving part of that communication attempt, right? So that they can't just write out and say, well, I'm not required to consult with that treatment court. That I think might be a good marriage of requirement on our end and on their end. And hopefully that can solve the issue. And if we find that there's a lot of QMPs that aren't responding, then as you say, we could study it for a year and come back to the legislature with additional proposals.
Can you tell me how many, sorry, you want to be now done?
I think they're great ideas, JD, for sure.
Can you tell me how many people have volunteered not to use or been prompted to volunteer not to use?
Yeah, I don't know. So much of this happens behind the scenes outside of the purview of the court. And what I mean by that is a person has criminal charges, they get a defense attorney, they're having private conversations that are protected by attorney-client privilege with that attorney. And often I think attorneys know, look, if you're going to be in this program, you're not going to be drinking alcohol. You're not going to, and I don't mean to conflate alcohol and medical cannabis, but all of these restrictions, right? You're not going to be able to continue using your prescription drug that you may have been using all this time, perhaps, right? Particularly if it was one that was prone to abuse and resulted in part of your criminal charges, you're not going to be able to use medical cannabis. These are the sort of things that defense attorneys are likely saying to their clients from their own view of what the circumstances are. And then the person is willing to do it. Whatever I got to do, I got to get in this program. And we never hear about it. The person just comes in and says, Judge, I'm willing to enter my plea and enter into this program. And off we go to the races. So I don't think we have any sense because of that.
So really quick, and I don't know if we would have this data either, but do we have any information on people that don't even actually have a medical marijuana card, enter this program, and then now they have to sustain to other substances they were using, and so then now they go get a medical marijuana card because they can go through treatment, but then they can still use medical marijuana. So they, you know, to me, it looks like a loophole for kind of abuse, like nothing beyond kind of the negative side of this, but where, yeah, sign up for this program. And now I find a loophole where, hey, I can do my medical marijuana card, I can start using medical marijuana, the problem might not be used.
I don't know of any firsthand instances where an individual came into the program without any sort of medical cannabis connection and then sought one out after entering into the program. I think, again, largely because most people come in under the understanding I can't do that and be compliant, and then they just moved on and it's water under the bridge, they don't revisit it. It would be an interesting scenario, though, if somebody did seek that out.
When you and I first talked, I asked you about just general data that you guys may have on the number of people that enter a drug court program, not in relation to methamphetamines, but just in general, how many are asked to abstain from a legally prescribed controlled substance. Have you been able to uncover that data and provide it to us?
It's not data that we have. We've never tracked it. There's never been utility for it. It's always been in the aggregate, like it would be useful now. We've never had a need for it. It's always been an individualized determination and a one-off case-by-case basis. And it's not documented in a way that we could ever pull from our data systems for sure. You're a thoughtful group. Thank you so much for hearing from me on this.
Someone have any other questions?
Well, I have a thought, and I know everybody loves my thought. So my, I had a couple requests when we were going over this, and my, one was a consultation with a medical provider. But because we, as you know, medical cannabis stewards, we are always asked to not use this as a frontline treatment. We have to assume that anybody that's using this has they're at the end of their rope, right? That's how we're supposed to use it. So I'm really nervous about attempting to consult. And I know that that will work out differently when you're talking to people and saying do it this way. But if we're already having people feel compelled to voluntarily give up their medical cannabis because they're entering treatment, and that is happening in a number that we cannot get any data on. And then there's nothing in here about having someone else. Could we use the compassionate use board? Is there a way that we could work in tandem with a professional, whether it's that person's pharmacist, whether it's somebody from the compassionate use board, because this is usually other medications have failed or they've caused addiction. I really wanted a third, another, something set up so as a fallback if those just work. It's like a safety net, because in my mind, I'm thinking of the patients that have hit the end of their rope, they're addicted to drugs, their life is spiraling, and we're looking at taking away something that could be offering relief. And I'm nervous. My last thing was I wanted data kept. I would like to add, you know, that like JD was saying, who voluntarily gives it up? Because that's a piece that I thought that this law had protected against. So who's voluntarily giving up? I want that reported as well. I also wanted a sunset date. The reason for the sunset date is often once as we know, I mean, once ink is on paper, it's so much harder to get removed. So if this goes bad on year one, without some type of sunset date, I'm worried that we can't pull it back. That we will now have to argue to get to where we are today. And then I would like an easier pathway for us to have those numbers reported to us at least until the sunset date happens, so we can make sure that we made the right choice. Because right now, if we forget next year and we don't go and find these numbers, we don't know how many patients it was removed from. And whose job is that? Our job? Is that Rich's job? I say we make Brandon do it, but it could, but like, but like, who does that fall on? And so that's not defined either. So that's a number that I think could easily just disappear. And I could be wrong. I'm happy for any input on all of that, but those are the things that are giving me worry today, is we have no way to give these patients a safety net. This is all they have. We have no way to really track this, and we have no ability to pull it back if it didn't work.
Do we have any? Comments or questions or anything in there? And I think the difficult thing I'm finding with the change is it's the same I had last time. What's written in sections 2 and 3, we're essentially just asking to treat this like any other medication. Essentially, we're giving up with those protections. And so I mean, if a patient, there's nothing stopping the current program from voluntarily getting an individual to abstain from any sort of medication. I mean, are they afforded the same protections for all their other medications as well?
Medical marijuana is the only substance that has the sort of protection that you're talking about. All the other substances are subject to treatment decisions that can ultimately require abstention if necessary to advance their progress in therapy. But medical cannabis is the one solely among all substances in the state of Utah where that's not the case. So that's the challenge that we see in trying to find alignment between subsection 2 and 3, because subsection 2 says treated the same, but subsection 3 says except it's not the same because unlike all these other substances that could require abstention under the right circumstances, medical marijuana is not one. It's the only one that's not that way. And again, this isn't our effort to whittle away at patients' rights. The focus here for us is to make sure that we have within our ability, within our power, the ability to make sure we remove every barrier from a person progressing in this program and not ultimately failing and being still in the criminal justice system or going to prison, losing their family. The consequences are so dire that if medical cannabis is in fact a barrier in an instance, then there ought to be a way to alleviate or eliminate that barrier for the time being so that the person can avoid really traumatic consequences in their lives.
What brought this up originally? Was there a case?
Judges just being concerned about not being able to interpret both provisions, subsection 2 and 3, in harmony with one another. The worry that people were not coming into problem-solving courts because there was a concern that they might be required to abstain from their medical cannabis, even though there's not clarity in this space about how it would work, right? Concern about people who it's a barrier for, but we don't have a specific case, right?
So judge
treatment provider driven as well. Yeah. And community
treatment providers that had experienced issues.
Sure.
Can elaborate on, because I think that's where I'm having the issue is there's no examples that are being provided to us as to what's driving this beyond you saying judges are feeling, conflicted about how to interpret law. As a lawyer, in my former life, we're always conflicted about how to interpret the law, right?
Right.
In every single case, one side of the B and the other side of the B have different interpretations of the law. And so to me, I really think unless there are some concrete examples, what it really suggests to me is this page that talks about collecting data should come first. And there should really be a collection of data to determine how often this is being seen as a potential barrier in people's lives, how often this is coming into conflict in this program. Because while I'm not a judge, like I've said, I don't see a conflict between sections 2 and 3. And I think what the public policy of the state of Utah is saying is that cannabis is a protected medicine in a judicial proceeding, right? You can't consider my use of cannabis any different than you could consider my use of the Percocet, as long as I'm using both of those lawfully, right? In the proceeding. So you can't determine child custody based off of, by saying, hey, cannabis used to be a street drug, whatever the stigmas, whatever the 100 years of propaganda against it have been, you can't consider that any different. And then, as long as I'm using it lawfully, you can't require that I abstain from it. I think the public policy is absolutely clear, and I would think that if we can't articulate, we can't kind of aggregate how much of a problem this is, I really think data collection is probably where we should start instead of abridging the rights of medical cannabis patients. I'm not saying that the concerns aren't real, right? Because as I talked to you over the phone, the last thing I would want to see is someone who wants to participate in one of these programs, have a bad outcome in the program because of their medical cannabis use. I could see it much easier if their crimes they committed were due to cannabis possession, cannabis trafficking, those things, or cannabis use disorder, or the use of cannabis. I can see why you would say, hey, probably want you to abstain from cannabis while you're in this program. But just as a general proposition, I just can't see it. And I think the fact that we can't aggregate the data, and even when I asked you about the story of the judge, right? I know I put you on the spot a little bit. Sure. if we don't even know if those three people that have come in front of that judge, whether they've been asked to abstain or not, I really think there needs to be more, more thought as to whether this is the right policies. Just because a judge or judges feel uncomfortable interpreting the law, it's what they have to do every day. That's why they put the robe on, that's why they take the bench.
Totally.
Right? So I just think that it would be my recommendation, that we collect the data first. Because from your own words, this isn't a large problem, right? There aren't a number of people that this is the cause.
We don't anticipate that it's gonna be a large group of people affected. I think
So
that's right.
in my estimation, if this were gonna be thousands and thousands of people, and you could come in here today and sit here and tell me 15, 20 stories of where this has really been a significant issue.
Yeah.
I probably am more at a place where I'm ready to start looking at some statutory language. But if it's a small number and we can't even articulate how big or not of an issue it is, what's the harm in collecting data for a year and coming back to us, in before the 2026 legislative session, and we can then look at what the data really shows us, because cannabis is one of those things, for better or for worse, that, the data doesn't always seem to, add up, right? You know what I mean? And a lot of it is based upon opinions, thoughts, and feelings. So I obviously have my thoughts, opinions, and feelings on cannabis, but I don't want to make a decision without knowing what the widespread effect of this could be, because there are some advocates, including some that are sitting in this room, that fought very, very hard for these things. And as someone's already said today, once ink is on paper, it's really hard to get back off of paper. And if this proves to not be the best decision, that's a lot harder to undo than making the right decision. So I think I would advocate that the second portion of this be done, whether it's legislatively required or not. If that data can just be collected and made available, and I think that will lead to a better decision. But that's just my thoughts.
Yeah, I appreciate that. I will say that we won't be able to get the data because there isn't a mechanism to have people in a problem-solving court currently that complies with subsections 2 and 3.
But you could at least gather data that says how many people are coming into problem-solving court situations with a medical cannabis card.
They won't be coming into problem-solving court situations in large measure if they have a medical cannabis card, because their attorneys will be telling them, you're not in a position to enter into this program unless you're willing to abstain. And the person may say, well, then I'm not going to even apply. And we will.
So is that you telling me that it is essentially a criteria to be involved in one of these courts to abstain? So I'm just trying to understand that part of it as to like, if their attorney's telling them to get that, but if you can't cause them to abstain from it, then in theory, they can still qualify for the program.
But they won't even apply.
They won't even apply. Okay.
Right? So we won't even know. The nice thing about this proposal, for what it's worth, is that I think it actually tends to legitimize medical cannabis use among the treatment community and within courts, because it says you can come into this program and you can use medical cannabis like you can any other lawfully prescribed substance. And only if it is determined that it is a barrier to your individualized progress, which requires consultation with the QMP, can you be required to abstain. This, I think, has a possibility and an opportunity of allowing treatment providers to learn from QMPs, judges to be more thoughtful about the people that they're interacting with on an individualized medication-based basis, and allow for people who would exclude themselves voluntarily from the benefits of a treatment court program from feel comfortable that they can enter that program, because the statute protects their abilities and requires an individualized determination of barrier before they could be required to abstain while within the program. All of this seems to me to be a beneficial opportunity for medical cannabis use in the state of Utah. And if we collect the data and you find that it's being used as an opportunity to require every single person with a card to abstain, that's not the intended purpose. And then it should be shut down, because that's not how it's supposed to work. That's not compliant with subsection 2 of the statute, right? And that's why consistent with subsection 2 was added at line 39, that the person may be required to abstain consistent with any other medical substance, right? Any other prescription substance. So I hear where you're coming from, JD. I get it. I don't think we'll be able to get an accurate picture of the data in the absence of a solution to the tension between subsections 2 and 3. Judges aren't just uncomfortable with it. It's that they can't find a way to reconcile the two provisions and have them be harmonious. And as a result, I believe there are people who are not taking advantage or not able to take advantage of the treatment court program because they voluntarily exclude themselves from even applying. And that's a travesty in my mind and in the mind of judges. This is the most fulfilling and rewarding work that most judges get to do, because often it's, you come in, criminal violation, I sentence you, that's it. And all I know is a few minutes of your life. Treatment courts are, I get to know you as an individual. I know who your family is. I know where you work. I know all of this about you. I know what you like and don't like. I know what you're struggling with, and I want to see you succeed. And at the end of the day, hugs and rounds of applause when a person graduates from this program. Judges love having that sort of interaction with people. This is the sort of group that we're trying to serve, and yet we may not be able to fully because of the tension between the statutes.
Quick question on there. Have a lot of this been happening because there's been a reduction in individuals participating in the treatment course?
I don't know if it's happening because of, in terms of medical cannabis conversation. The population across the state ebbs and flows over time. A really big impact to to problem-solving court involvement was when JRI was passed by the legislature, and many offenses that had been felonies became misdemeanors for the first and second and even third offense, depending on the substance. That resulted in a lot fewer people who are facing felony charges, and that can be a really great carrot and stick for an individual to motivate them to engage in treatment. That changed the dynamic. I don't think this has changed drastically, the number of people in these programs, but I think every individual matters. And so having a solution in place for them is important.
Yeah. I mean, and again, I agree with the point that every individual does matter. And I mean, my biggest fear again is going back to the first comment I made, is this attempting to consult. I mean, if we were to see language that says only after consulting with recommending medical provider.
Sure.
I mean, regardless of the attempts it's made, I mean, they can continue to use it as needed. And you can't require them to abstain until that conversation has happened.
So long as there's a requirement on the medical provider to
And
respond.
well, that's my next question, Rich. I mean, Rich oversees the QMPs. Is that something that could be added to the language to help assist with these problem solving courts?
Under the statute, yeah, it could be added to the health code, 26B-4 is where it would be just applicable to all qualified medical providers. Yeah. And then if we got a case about a QMP not being able to be contacted, we would investigate it. And it might be something that would be better actually in Doppel's law, because they can actually take action against the professional license. We can't, we just take action against the registration with our program. But any violation of our law is also unprofessional conduct action on their side. So either way it could happen. Yeah.
I think it's reasonable to give a time frame within which, because it's understandable, it might not be an immediate response, but it should be a reasonable amount of time.
Right.
The physician has which to respond.
Mm-hmm. Yeah.
If, say it's drug X, say it's not medical cannabis, not alcohol, not narcotics, not anything. If a person participating in this court is asked to withdraw their use of drug X.
Yeah.
And then at some point during their treatment is, I'm assuming, tested and found to be positive for drug X, what happens?
They can face sanctions
excused?
within the program. No, they're not.
Or
When you're dealing, you all know this, I don't need to preach to the choir, I guess, but with a population of people who are prone to substance abuse, we should anticipate, especially if they're high risk, high need, we should anticipate that they're going to show positive for the use of illegal substances, because otherwise they're not addicted, right? If they can just voluntarily turn it off. And so there is a significant amount of research and infrastructure within the treatment court program to anticipate and deal with use within the program without eliminating the person. In fact, the person who continues to use in a problem solving court program is the person we most need to have in the program. To kick them out would be the mistake, right? And so it's a graduated, increasing degree of sanctions. Some of it is like, hey, you're going to write an essay about, you know, and go through that with your group or your treatment professional. Or you're gonna do, you know, 4 hours of community service before the next court hearing. Or ultimately, we try not to use jail because it's the ceiling and you don't want to max out on negative consequence. But ultimately, it may be that you're gonna spend a day in jail and think about whether or not you're gonna continue to use.
That's helpful.
Yeah.
Thank you.
Great question.
Is there anything else anyone wants to add?
I think the other data point that I would like to know is that could be collected from this is sort of like recidivism, like okay, if we establish that maybe this is an issue, and this could apply to anything, any drug X, could how many is this a repeat type of issue? How many times can people participate in drug court?
Multiple times,
So-
depending on, you know, the criteria, the meeting criteria.
But that in itself would be interesting to find out, you know, what is bringing them to court, first of all? Is it the same thing from time to time? Or is, you know, is it different things to bring them there?
We may already have some data on that. We've been dealing with drug court populations for 25 years now in the state of Utah, and we have seen people repeatedly take advantage of and have the opportunity to participate in a problem-solving court. It's typically a return to criminal behavior that is, you know, the onset is the illegal use of controlled substances.
Yeah.
So that's going to be the typical. Ultimately, we would hope to have this group's support. I understand your concerns and hesitations. I appreciate you taking time to share them with us. We really want to get this right. So.
All right, thank you. We'll turn time. Just, is there any public comments or anything online? No one in the room. We'll just keep it in with the board. I mean, last time we chose to kind of table it for today. I appreciate Mr. Joseph's time in making some changes from what was presented the first time. I mean, if there's anything that has any motions or anything you'd like to make, so you can follow.
It's chewing on stuff.
I'll make legally, I actually think fairly reasonable. You know, maybe I really get your point too, but at the same time, we talk about the person choosing marijuana purpose set. In the way the law is currently written, if they go to this program, they can purpose it can be taken away from them. So I see it loophole for abuse, and I don't think people in these problem solving courts want these people to fail. I just think that personally, I think there is a little bit of loophole. So I will make a motion that outside of the little change of language to consulting, from a technical consultant, they must consult and add in the fact that the QMP has some obligation there too. I would make a motion to support it.
You have a motion? We have a second?
Second.
Can we modify the
Yeah.
motion?
Yeah.
Because I think it's-
Substitute.
Or make a substitute? I minimally would like to amend it to collect the additional data points that we've been talking about in 5. So if we're gonna make a requirement to consult, which I feel strongly about, then help me remember everything we talked about adding to it. It would be potentially, we wanted to know the number of people who are voluntarily removing themselves from the program. Whatever the correct wording is for recidivism. I don't know how you would word that appropriately. Perhaps even if there's a way to quantify, since we're not going to look at the number of failed attempts to reach the qualified medical provider, maybe the time of response of the qualified medical providers, if there's a way to, you know, did it take, if there's a way to quantify, did you get a response in a day, a week, whatever is appropriate. it might help to find the logistics for the DOCL office, say if you were to take it to DOCL. Because I'm sure they'll want to know what's the time frame for response. In case a year from now, we have to go back and look at this again, we can have data to support. A week is a reasonable time frame. Or is 72 hours a reasonable time frame, or is 24 hours a reasonable time frame?
Could I make a suggestion on that? I hate to,
Please,
it's with the board. I don't want to intrude.
Yeah, you can.
Oh, thanks.
you have the most experience with this, with the court side.
Well, generally speaking, we get a lot of requests to collect a lot of data, a lot of requirements to collect a lot of data, some of which we find, much of which actually ends up having limited utility ultimately, but it required people to take the time to record the data. And I'm wondering if it might make sense instead because these consultations should be documented within case notes and other things. We could audit some cases after the fact without collecting data in every single case as to how long it took for a qualified medical provider to respond to an intent to consult. We could audit cases and determine if in fact it's a problem. It may be that 2 weeks is never a problem. We never hear that it's an issue, or a month is never, is not determined to be a problem. I think it would fall into the same practices that the treatment professionals involved in these programs are undergoing when they're trying to talk to a physician about any other prescribed controlled substance. We don't collect data on that, but we could audit it if there were ever a need. I just haven't heard that that's ever been an issue, and I'd hesitate to ask people to spend the time collecting the data until it is seen as an issue. QMPs may be awesome, and it's never, a thing. So.
Yeah, I just wanted to make sure we didn't miss any of the data points there.
I do think we could track how many times we make outreach to a QMP and don't get a response back, so that we know if it's a big issue or not. Whether or not that ends up as a DOCL thing or if anybody's ever even held accountable. I would love to come back to this body in a year after this session, if this were to be supported and passed, and talk through the numbers and talk about how on the ball QMPs are, or if it's 1% of the time or 10% of the time or whatever. And to Desiree's point, I would personally commit to bring this information back to this group after the first year and make sure that you know what the numbers are looking like. I would put it on my own calendar and I would track it as an obligation to the board personally. So.
All right. And then I know Desiree Robert substitutes the need for a sunsetting date. I mean, obviously, this is a failure. We don't have the ability to give back to someone and say, hey, this is successful or not, this is even needed. If not, this rule changes for move. Typically, what's a good sunset date? 1 year, 2 years?
Yeah, they do one to 3 years usually.
Could I make a recommendation that it be at least 3? And here's the reason why. The law goes into effect. And then you have an application period of time for people to apply into a program. The program can take anywhere from 18 months to 2 years while they're participating in the program. And then we get some outcome data on a handful of those cases. And so if it's just 1 year, for instance, we'll come back and say, well, we know of 3 instances or whatever it is, right? Because there hasn't been enough time for it to ramp up. So maybe worthwhile to have a ramp up period sufficient that we understand what's going on.
You have all that, Abby? It was a lot.
Yeah, I think so. So do we need to do separate votes then, or just one vote?
I think we probably should do a big motion.
Yeah, and just repeat
Yeah,
it.
you just repeat it to us, and then Jimmy will just
Yeah.
make the motion.
So I just know.
For sure, I think it's reasonable.
So for the first, Jimmy motion and then Karen seconded it, and it was to change the language online for United Football to, they must consult.
It's 9:35.
Or 35.
They shall consult.
They shall consult.
With the disclaimer that we would put something in on the QMP side where there would be a requirement for them to have some reciprocity.
Yeah.
And then with the data collection, what's feasible as far as where the attempting to consult did not work. With that, yeah, so at least collect that data point and then a sunset date for 3 years. Founding members.
I think the other word change would be in line 46, that the number of participants for whom it is determined that possession or use of medical cannabis, sorry, I can't read today, presents a barrier under subsection 4A. I think perhaps considering for whom it is determined in conjunction with the QMP that possession of the use of medical cannabis presents a barrier.
Yeah, after
So my
consultation.
understanding, we're keeping all this language, all these data points right here, we're still.
Yes,
Yeah,
yeah,
the only one. we would
they
add
would just
is-
be adding.
Yeah, the only one we would add is the guarantee. As far as the, so.
All right, do you want to read it back to us, Abby, and then, someone needs a second to the motion. Okay, and someone will- if you want to read it back and then do a roll call vote.
Language on line 35. Renewal to, they shall consult. With the disclaimer that there would be, that QMPs are also required to respond to problems solving board requests. Line 46 should read, to whom it is determined with consultation with the QMP. And collection of following data points. Number of people who are voluntarily removing themselves from the program, recidivism, response time of the QMP problem solving courts, and the success of reaching the patient's QMP to control, and a sunset date of 3 years from the time the rule comes into effect. Jimmy Higgs,
Yes.
J.D. Lorenzen,
No.
Chris Morgan,
No.
Matthew Page,
Yes.
Misty Smith,
Yes,
Kenneth Anderson,
Yes.
Nanette Beresney, no, and Candy Clark.
yes.
Yeah, it says right
Oh,
here.
sorry, Desiree Hennessy, no.
The rule does pass 5-4. I appreciate the time and effort into that, and Mr. Dreschel will give you a copy of what we voted on as well. We just sent an email to the legislative body, with a number of rules that they had votes for approval. So everyone will receive the version of those.
Thanks. Whatever I can do to help, let me know. There remain a year back in call, so.
Thank you.
Appreciate it. Thanks. All right, we'll go ahead and move on to the next item. So item 6, titled Factors Impacting West Encore Holders Domain Purchases in the Program. Just for some background into this, I believe many of you were copied on this email. That after our last meeting, we received an email from the drafting for the Associate General Counsel, Chris Williams, who oversees and manages the local governance. Senator Bickerson reached out and is asking the industry and others to discuss and brainstorm on why we have approximately 90,000 patients, and we see about 15% of those purchasing products within the cannabis pharmacies. The assumption is, well, then that means 50% are either no longer purchasing or they're purchasing from other sources. So during some feedback sessions and discussion, we had asked the Department of Health to provide us with data based off of purchasing. And so we do have that, and I'm going to turn this time over to, is it Rich, will you be presenting that?
Yes, and then it'll be presented online. Can you present that?
Yeah.
Great. Great, and also for those joining online, a copy of this presentation is on the public notice website. So you're able to review that on your own time as well. And then for those here in person, I believe a copy of it is available at printed, right, Abby? Right, so if you wanted to have your own printed copy, you can come grab that if that's helpful as well. Okay, so as Matt said, I'm Rich Oborn, Office Director for the Center for Medical Cannabis at the Department of Health and Human Services. And let's go, to the background. So We were just asked by the chair and vice chair of the board to gather information about how many medical cannabis patients make purchases at medical cannabis pharmacies opposed to those who don't. And that's the purpose of the presentation. And so if we dive into that data request a little deeper, in essence, what we got was a request for information about the total active patients by month and how that's worked out since the beginning of the program, and then total new patients by month, total renewed patients by month, and then of the total population of the patients ever, a few data points there, and then how many patients have been making a purchase monthly, and then at least once a quarter, and then each once a year. So that's what this presentation provides. Next slide. So this shows the growth of the medical cannabis card holders who have active cards since January 2021, how that number has increased. And so, as I stated earlier, we're almost to the January 2025, obviously, and we expect that that will reach approximately just over 100,000 in April. So this just shows what that trend has been in growth. And then each month right now, we're experiencing about a 3% growth each month in that number. And if you compare the 2023 growth percentage to the 2024 one, we're projected to be at about between 31 and 32% growth for 2024, whereas 2023 was 30% growth. And then at total new patients by year, this shows that. And so this shows, and if you'll just see the data points there, those are moving up and down based on monthly numbers. So the peaks, those are mostly in April of that particular year. And then you'll see it goes up and down there. So next slide. Or you're already there. Total renewed patients by year. This is obviously up and down, but the trend is up. Obviously, with the higher total number of individuals with cards, we notice the renewed patients by year goes up. And then of the 159,221 patients who have ever had a card, 10% or 16,600 have never made a purchase with that card. So these are individuals whose cards expired years ago, or it could be people that still have a card today. But anyway, those individuals, 10% of them never made a purchase in the state's medical cannabis program. And this excludes non-resident caregiver and minor guardian cards. Those are very small numbers, and to avoid confusion, we remove those. And now we can move to of the 159,221 patients who have ever had a card, 4,200 or 2.7% have never made a purchase and have renewed at least once. So that represents someone who had the card, got it initially, and then they, by their own choosing, went and met with the QMP to renew again. They paid that fee to renew again, but never during that initial period and that renewal period did they purchase at least once. They didn't even make one purchase. Okay, and then of the 159,000 patients who have ever had a card, 14,868 or 9.3% have only made one purchase. Okay. Percent of patients with active cards that made a purchase each month. I think this is where the lawmakers and the industry were talking about where the concerns were focused on was the 50% number. I think that comes from here. So we think about like actively, what does it mean to actively purchase medical cannabis? I think we can say if you're purchasing medical cannabis each month, that you're an active purchaser of medical cannabis, right? So approximately 51.8% is where we are at. So about 50%, that goes up and down, obviously, but yeah, that's where that's at. Are there any questions about this table or this graph?
Do you know when this data on here, I'm just trying to put about what you just stated as far as active appreciation. Is this just saying patient made a purchase, that's the numerator, the denominator was the 91,000 patients with active card. That's all this is said it is?
This takes each month by month. That month, there was a specific number of active medical cannabis card holders, right? How many of those made a purchase that month? What percentage of the total number of card holders made a purchase that month?
Yeah.
And I've got Jesse Hockley here, who's the data analyst that prepared this data that could go into more depth, but correct me if I'm wrong, Jesse, does that sound like an accurate description?
The numerator is just the number of patients who made a purchase, on the denominator is number of patients.
Yeah.
Did you use the data based off the number at the end of the month? As of like
No, I
November 1st?
use, so for this, usually for a monthly report, I would do the end of the month. For this one, I did an active card at any point in the month. So even if it was a single day, I counted that for the denominator.
Okay. Do we have a lot of patients that have, so you're saying that their card expired on the 2nd?
Yeah, so,
Okay.
yeah, so it's not like inflate the counts of like purchase, they made a
Yes.
purchase and expired in that.
Okay. Right, that answers that one question. Don asked me correctly. He answered it.
Great. Okay, let's go to the next slide then. Percent of patients with active cards that made a purchase each quarter. So the quarterly purchasers, this is what that looks like, obviously slightly higher percentage. We're at about 68% during the Q3 of 2024. That's where we're at. And then percent of patients who had an active card within each year who made at least one purchase, any purchase. So in 2024, so far, we're at 81% for that. Of the 117,000 patients total that had a card. So far during 2024, that's the percentage that made at least one purchase.
Can you go back a slide? So when I was some of the data, and we kind of talked through this, there's some emails that went back. The logic on looking at a quarter was, oh, we're trying to treat more like a traditional medication, a lot of people purchase a 90-day supply, save on savings or bulk purchasing, and so. And obviously, you see an increase, right? So you're going from a roughly 52% average purchase to an average of about 70%. Roughly with time on that data set. So I mean, it is quite an increase. But I think if you go back to just the full year purchasing, it's the next slide. So, I mean, looking at this, I mean, we know the number of patients was roughly 91,000, right? So we had roughly 26,000 patients that this year bought something that no longer have a card. Really what this is telling us. That's a side. Now, again, it may be, they found cannabis is no longer effective for them. And that would be, I mean, the survey, maybe the job they got, they're not protected. Right now, they're getting job protection, depending on how severe a state employee. And so, I mean, there's a lot of reasons why people choose not to continue with cannabis. I mean, I know from studies we've seen, usually that's either the cost of getting the card or the cost of getting the medication. These are the two primary reasons. And so what Senator Vickers is asking us is, you know, we get told a lot, hey, 50% of the patients aren't buying something every month. Well, you know, they may be buying enough to last them 3 months, so that's kind of 70%. And that's a much sizable number. So that's why we're not seeing it actively every month. It doesn't necessarily mean that 50% that aren't buying are going out to the streets and buying it off the corner or going out of state. There could be a lot of other things that fall under that number. I mean, obviously, if we drive out to Wendover, I mean, we get told this all the time, majority of the plates are off from Utah. So, and there's obviously anecdotal data that we can take from that people are purchasing from out of state. And why is that? What we do to address that? And so I think as a board, kind of what we wanted to discuss, just open discussion today, is what can we do to help get patients to be more active in their purchasing? And what can we do to so do you have something to add?
Well, I just echoed, Rich, remember that survey we took back in June on reasons why patients expired?
Yeah.
And I just share a little bit on from that survey just to fix it a little bigger. Oh, yeah, sorry. Let's sleep.
Yeah, so the survey Jesse's talking about is something that the board actually requested that we do.
Oh, we already did share that. So.
Yeah, well, we haven't talked about it today yet, but it was shared back in June. And it identified the most common reasons based on those that responded to the survey as to why they allowed their card to expire, right? And, you know, these numbers are those individuals that bought, how often they bought, but these are people that couldn't buy anymore. Why did they choose not to be in the program any longer?
Yeah, and I pulled that up just to add a little bit more context before we move forward. So we had 2,450 some odd patients respond. Of those, around 1,200 cited medical provider being expensive as a primary reason. Second highest was a little over 1,000 cited pharmacy being expensive as the second, as a main reason. The third group was about 500 said out of state dispensaries were cheaper. And the number 4 was just they moved out of state at around 350 people. And then continuing from there, just cheaper products from personal source, about 250, and then ongoing.
Yeah, and they could choose multiple reasons.
Yeah.
Personal source. We need that.
I mean, I think again, the point of this topic on here is just kind of for us to brainstorm. I mean, Senator Vickers would like ideas on what we can do. I know a lot of groups have already reached out to him, and and Chris Williams with some certain proposals that they'd like to see this in that legislative session. And we're hoping both the patient, how to retain the retention level of patients once they enter the market, but then secondly, how do we get just grow the patient count itself to educate patients. And you know, one thing I'm real big on is how can we get more education out to Utah citizens that there are safe Utah tested products out there available. And now again, I'm not trying to pitch what QMP or what medical doctor they need to get to. There's no products or anything I think the state should be proposing. It's just simply stating, hey, here Utah has state tested medical cannabis at the website. I mean, I think an education piece on that is something that could definitely help, especially as we're getting a lot of citizens that just drive right across the border, and it's not just Wendover. We're surrounded by 3 states that all have recreational programs where cannabis can be found, and it doesn't necessarily equate to being cheaper. It's just a lot of it comes down to their access here, so they just find, hey, it's better for me to go there and buy bulk
even if they just feel like they have less hurdles, they'll
Yes.
take the drive over the hassle.
Yeah.
Which is, I mean, we created these programs, we get a patients, not criminals, and that's what we said over and over, patients, not criminals, and a lot of this is pushing them back into that like criminal box. So, not.
I think, a lot of this, starts with the QMP. It's typically the patient's first point of contact with this program. And it's incumbent on the QMP to provide that initial, orientation to the program of the patients, understand, what the law is and, and what the products here are safe. Not the fact, not that they're necessarily, the least expensive, but they're readily, the dispensaries, are located in fairly, let's say, the most patients here. I think, that initial step starts with the QMP, making sure that they're educating those patients and not just making recommendations.
Well, I think it's a multifaceted, problem, right? There's no one thing you can point to that probably explains why only 50% of patients are shopping, in the right? I'm sure some are very concerned about cost, right? Some are concerned about the fact the form factors, that are available in Utah are not consistent with what are available in other states. I understand that we've made, to this point, a public policy decision around, plain flour. But I guarantee a large portion of those people that are shopping in other markets are shopping for smokeless, right? Stuff that we don't allow here. Chocolates, right? This board directly recommended that we allow chocolates, just let you shot it down. We have the ability to have, to have larger liquid suspensions in the program, right? Legislature removed that. So part of it is that the way I believe we do this is we grow the patient population generally. More patients generally is going to mean more orders, which means a better chance of profitability for businesses. As businesses become profitable, they're able to bring the costs down, right? Our own data that we're tracking shows that on a per milligram or a per gram basis, most form factors have seen prices come down over 20% in just the last 2 years. I understand it doesn't compete with the illicit market. I believe Narrative has said this before. We're never going to compete with that market. So if that's who we're being compared against, we're going to lose every single day of the week. I also think it's not apples to apples to compare us to adult use markets, especially mature adult use markets that have their own problems otherwise. You look at a lot of these programs and you see very cheap products. Wonderful, right? Wonderful for the consumer, but is that going to be sustainable in the long term? And you're even seeing certain states now consider limiting the number of licenses that they give out, right? So to me, it's a multifaceted, problem. So the hope is you bring more patients in generally, that leads to lower prices. That seems to be the number one hang-up. If you look at any of the surveys, the analysis that UDAP did, that seems to be the number one concern. We've already seen a trend in that direction. So as patients have trended up, prices have trended down. At the same time, the number of form factors available, the quality available, right, and those types of things has trended up. What we need to do is we need to attack it from a multi-front approach. So we need to deal with the ability to get a card, the ability to renew a card, and the ability to then maintain yourself as a patient in the program. Some of that is going to be on us as operators to continue to scale and improve our operations and produce products that demand what the patients are demanding. But some of it is the legislature helping us to remove some of these barriers that it is to be a patient. And that, I believe, will bring more patients to the program generally, drive costs down, and hopefully drive some of these folks back. But at the same time, too, some of these 50% of patients that aren't shopping are going to continue to obtain a card and purchase in those other markets because we'll never be able to match. And I think to Matt's point, that's where education comes in to help people understand, hey, I'm not saying the other market, the adult use markets in other states, they obviously all have their own testing programs. Presumably all those products have passed testing and they hit shelves. but the illicit market, helping people understand what you could potentially, not guaranteed, could potentially find in those markets. And that's the approach that we're taking at the legislature this year. And I think that the most, the rest of industry is taking. And that's why I think, anything that slides us back towards the criminalization of cannabis is not the answer, right? We tried that as a country. The war on drugs lost. Drugs won the war on drugs. It's just the way it went. Who really lost that war is the people, right? And if people continue to lose, that's what I think is a mistake. And so what we'll be supporting is things that increase access to medical cannabis, treat it like other medications, especially as Schedule 3 is coming. I know how soon Schedule 3 happens is anyone's question if you've been told and all of that. But to get it a lot closer to how those other medications are being treated, right? And try to implement some of the statements. So.
And you guys all got the email, I think, because I'll read my priorities that came out. To JV's point, I think coming at this from different angles is the only way to kind of tackle this beast, because it's multifaceted. It's, the leaks or whatever we want to call it are coming from everywhere. And as much as we don't want to compete with the illicit markets at all, like that is our number one competitor, and it always will be. In looking at the reasons why patients are not renewing, just trying to think of something that would be like low hanging fruit, right? Why are we having trouble? There's lots and lots of reasons, but the low hanging fruit that I could see was, and I forget what state and which Trevor was here because he would remember. There was 2 other states that have done this. I think one was Colorado, and I can't remember who else. They had allowed people with like 65 and older to self-certify, basically saying like, hey, if you're 65 and older, we could do something 75 and older, but just like if you probably have pain. And it's not our demographic of people that are probably trying to use it recreationally. It's because they're 65 or older. I took that and kind of changed a little bit, and I was like 65 and older, disabled people or terminally ill. Should they be allowed to just get onto the Department of Health website, show some type of, yes, I am disabled, yes, I am terminal, here is my driver's license, I'm 65, and mark a box and then have their medical cannabis card. I think it goes without saying that would help a large population of people that are struggling to renew because of cost. And that's our number one, is cost for renewing. Then the other thing is, this has been done in a few other states, and allow QMPs to self-certify. So they're not taking a course. We've given them the cannabis education in their CME. They can take it. Not saying that they all do, but are we trusting our doctors to use their controlled substance licenses the way that they've, promised to use them to help people and not to hurt people? So we've already trusted them to do this and to have these controlled substance licenses. They're managing medications that are much more dangerous than cannabis, much more addictive than cannabis. Do we trust our doctors to be doctors and take away that self-certification? And why I came to this is my personal doctor, he's not a QMP because he doesn't want to take the class. He's like, I don't have time. Now he has become an LMP and he's reached his 15. And he's like, I don't have time to take the class. So he's not going to go anymore. Now this is a regular care physician that would be seeing it for his regular care doctors and to be charged of the copay. I would like to remove barriers for those. I reached out to some lawmakers on this one, and their input on this was maybe for NBs, DOs, but maybe not for NPs and PAs. But those are just some things that I think could help with the patient attrition issue, and maybe we could have some conversations there. I know these are all things that have already been sent to the lawmakers, and so they're already looking at them, but I'd love to hear your thoughts. I was told by Senator Vickers that it was radical. But he thinks I'm radical all the time. And but they're not when you look at what we're asking. We're asking people that we know are disabled, we know are elderly, or we know are terminal. I mean, if nothing else, please, let's let the terminally ill people just bypass. And I trust our doctors to be doctors. So I think if we removed those hurdles for those people entering the program, staying in the program, not having to pay a QMP, and then QMPs to not have to renew. And maybe we could open the door to more QMPs to see their personal patients. I think those would be very helpful. Disabled feels like a really long term. Yeah. Well, I think you have to have a diagnosis, like you have to be medically. You need like by the state. Yeah. Like yeah. Not
under
disabled.
SSDI.
Yeah.
Disability.
Yeah, like a disability or a term, so something that has actually been diagnosed. Like they would have to have something they could send into the state and say, I'm permanently disabled.
What about potential risk concerns like cardiovascular issues and screening for those?
Well, so oftentimes, and correct me if I'm wrong, but oftentimes it's not done that's done at the doctor's office. But if it's not, so if I see multiple different doctors and I'm getting drugs from different doctors or meds from different doctors, that's always checked at the pharmacy. And so, I mean, we have pharmacists at our medical campus pharmacies, and they told me that they always check. So they check for contamination.
Where did they get that information?
I don't know because I don't have their database. So where
They don't get it unless the medical provider shares it.
so then maybe we'd have to make something sure. So they did know what medications they were on.
Yeah,
Or
yeah. So I'm just thinking through this scenario, and what you described earlier was where they would have to provide documentation about it, right? So that documentation would be viewable by that pharmacist. It would be in the EBS in this scenario. And there would not be able to be anyone that would be able to get a card without that documentation being submitted first, right? Other patients are able to get cards without that documentation.
right.
Because we're trusting that the QMP, their certification means it's there.
But if they're doing a renewal and there's a change in status as far as a prescribed medication or a cardiovascular risk, that would be missed in this area.
Yeah,
It could be, yeah.
yeah, that's a concern there.
What is the, I guess it doesn't matter to me necessarily, but the cardiovascular risk is more with medication, right? So it'd be like, they need to go take more INRs than, right? I mean, just make sure that it's not like, then if they've blood too much.
Not necessarily, you know, hypertension is a really serious concern with medical chemists. Users as well as history of probably stroke or other major events has occurred, which can occur. You know, I've seen it between renewals and after the withdrawal part due to new condition or something that's happened. So I mean, there is concern regarding, you know, self-certification, you know, that self-certification will include that they have, they're testing, that they consult with their medical provider regarding their use of medical cannabis. And there hasn't been anything, you know, recommended against as far as the medical devices. And so it'd be more of a self-certification as well as an attestation that they have consulted with at least their primary care provider regarding the continued use of medical cannabis.
Yeah, maybe we could make it so, because I mean, we have medical professionals, we have pharmacists that are checking every single exit, you know, and every leave to the pharmacy, they're checking it every single time. So there, I feel like there's an opening here for us to be able to use them and say, okay, so then anybody who self-certifies gets so much more time with the pharmacist or whatever, like the pharmacist has to review and everything, because if it's just medication issues or something like that, and the pharmacist can easily be like, yeah, I can't fill these for you until we make sure that you are not on this medication, like, they check. I know that if we give them the ability, they're still medical professionals, they'll check. I just am trying to think of a way that we could get these obvious patients that are using it, that qualify to be able to not have to go through all of the hurdles, and just end up using an easier market, and which was what they're doing. And they're not, nobody's checking. If they have cardiovascular disease when they go into birthing, or when they go into, when they use their neighbor, right? It's not being tested now. So either way, this is a step up if we're at least having the pharmacists look. Because the assumption here is that we're just trying to, this isn't pulling people into the market. This is keeping people in our market and not using the outside market. So I feel like there's gotta be, I'm sure we can come with some idea that can make it palatable for everybody, check all the boxes to be able to get people to be able to self-certify and use the pharmacist.
And then you're talking about a certain population, such as 65 and older, right?
Yeah, or disabled interval.
Or part of the self-certification process might need to include, now obviously they would need to meet with the QMP at least initially, but on recertification.
Yep.
If there was something in EVS, for anybody who met that population criteria to fill out a specific electronic form that would be available to the pharmacist, and they would need to list their medications or whatever, as part of the self-certification and attestation process. That could be a potential way to, for the patient to get at least volunteer the information, the medication and such, and even potentially list pharmacy that they're using to fill the medications.
Quick question, this is more for Jesse. Yeah. The data that you provided, is it possible to get it by age group categories? I know we do a lot of reporting on that anyways, as far as number of patients fitting in this age bucket. At least maybe active cards versus inactive cards, so I can see, are we losing, are
Is the
80% of all the senior citizens that get a card not renewing and just canceling their card?
Yeah.
Do a
Maybe
breakdown.
it's not 65 and older, maybe they're the only ones that are doing it.
That's exactly what I asked Trevor when he put this out to us, it's where it was.
Yeah.
And I know there wasn't enough time, that's what he told me, that I wanted demographics information on, these responses, right? Because without knowing kind of, who's in what bucket, I think sometimes it makes some of those things difficult. But I think what you're generally driving at is just people Utahns that want to access medical cannabis should have the ability to do so without having to jump through, a lot of hoops, because I just know that's a reason why folks are either not getting the program, leaving the program. And like I said, while it doesn't seem like it aligns perfectly, like, hey, how do we track people back that already have a card? The more patients generally that are in the program brings prices down, generally brings those people back up. That's our best tool to bring them back is price. That's what we're competing against with most of the other markets.
Well, and if we continue to make it easier for patients to use outside markets, there's eventually going to be a push from, I'm not saying Jimmy, but I'm saying maybe some of his friends to turn around and fix it, right? And then what are we doing? We're ticketing patients that just couldn't afford it. It's not gonna be the ones that could afford it. It's the ones that can't afford a lawyer. Those aren't the ones that are gonna be targeted. And so helping those patients get into our market, use something legal, get good quality medication and not black market product is what I'm doing here. And to be fair, I think that's the radical problem, is that they're not in a safe market. They're not being followed by a physician. They're not, they are one or, pull over away, what do you call it? Maybe one traffic stop away from getting from being a criminal. Yeah, and we are trying to, we're trying to think, how can we entice them to stay? If it's cost, can we move them?
So that would benefit patients, but since there's not a lot of information on how to dose a lot of times, if you freed up those finances, we would put it back into the market for people to buy products that they could actually try. Because right, put a whole bunch of money into it and like, now I have to keep sinking money into it and not even sure if it's gonna work or not. Oh yeah, I think that would be a big problem solver for a lot of people.
But I could, part of what we talked about is a recent survey was done, recent polling was done around the election. Adult use cannabis is pulling 50% in Utah, right? And for a long time, the argument has been the more accessible we make medical cannabis, the easier we make it to be a patient, that's going to drive us to an adult use market. It's the converse. The more difficult that we make it to be, to become and stay a patient, the more likely we are going to have an adult use program. And so what we see these things as is not a sliding slope, a slippery slope, a sliding scale, whichever one of those things you want to use, towards adult use cannabis. This is how we preserve the Utah medical cannabis program, is by doing these things. The program has shown itself to be responsible, right? You know what I mean? And 91,000 people, right, based on the numbers that Rich gave, have been finding usefulness for medical cannabis. I think we have to start thinking about this in a different way. If we don't do these things, we're going to see an adult use cannabis initiative in Utah. We may see one anyways, right, at some point. That may just be where Utah gets culturally. But the states that have gone adult use, for the most part, have been forced to do so by failing medical cannabis programs. And if I would hate to stand by and just say, well, we'll see what the voters decide to do. Why not find ways to improve the program that we have? Keep a medical program. The operators want it to remain medical. Everyone sitting at this table wants it to remain medical. I don't want to speak for the departments, but I get the gist from all of you. So why not do those things that are going to help preserve the medical nature of it, and allow people who want to gain reasonable access to this medicine to be able to do so. And so I think if arguments are made that no, this is going to push us towards adult use, not doing that is going to push you towards adult use, and the voters are already there, right? When those polling results, were released, I thought we would have been lucky to see something north of 40%, right? The voters, 50%, and if you want to look at demographics, it's coming, right? Anyone under the age of 30, it's overwhelmingly in favor of adult use, right? I think 60% is in the youngest, demographic margin, right? And it's the older populations. That the ones that Reefer Madness got a hold of, all those years ago, that are still obstinate to it. So I feel like we don't have a choice, right? We need to explore these things, and if we don't, you're going to see an adult use ballot initiative in 2026, and that's just the facts.
And I will say, and I'm assuming they've reached out to JD, but I've had multiple organizations that have the money to turn this into an adult use after we ran that poll. Multiple people with the money to run an adult use ballot initiative reach out and say they're ready to fund it. And I'm not there, but so that's the radical is going that way. I would like to find ways to keep this a medical program and support the medical patients in using our market and not using the black market, and not using deep roots, although deep roots, people love their products, but ours are medicinal. They're not recreational, and we're not focused on high THC. We do have talks about terpenes, and we do talk about diagnoses with blood terpenes, and that's available here, and we're getting better every year. And I would like to continue that trend. So yes, so those are probably my two things that I feel like benefit our program long term.
And just a stat that I think you might find interesting is 10.8% of current active patients are over 65.
Which age group keeps their car longer?
Yeah, on which ones are getting rid of it?
Yeah. I mean, if it's under 30, based off that whole, you get it for, say, correlation, causations are mixed in statistics.
Yeah.
But I mean, there's reference that those patients are probably going to have some other methods that are making their art.
Yeah, with additional time, we can break it down.
I think it'd be good to get into, you know, I know we don't have time today.
Yeah.
Okay, I think maybe in our next meeting, or if you have time before, just to send something out.
Right.
As an addendum to this survey and to this analysis we received, just saying, hey, here's the same numbers, but broken out by the demographics that we currently track.
Okay, so you want more than just over 65 and under 65?
Yeah,
You want,
I think I mean, obviously we track minors and age 21.
yeah,
21 and 30, I'm checking for all the categories. Jesse knows them by heart, so.
right, yeah. We'll see if there's trends within the age groups that we separate for our,
I mean,
monthly
too small
report.
for any analysis, you probably can find it.
Well, I was going to say that we can't go too small because of data suppression. rules.
Yes.
You can infer.
Right.
Yeah, no,
Some of these.
so whatever that number needs to be, you need to be based on disclosure and to fill that, that's fine.
Okay.
But at least that would give us as a board some information on who's actually leading the market, what age group. And then I think when it goes back to what it allows us is how we target and market to those particular age groups within the state of Utah for education. I mean, this isn't an issue with just with these patients. I mean, every high school deals with issues with marijuana use. Across the entire state. I mean, I have high schoolers and I hear all the time that people are using it. And they don't understand the consequences that happen to being so young and using that without a doctor being involved. The effect we can have long term on them. And so I think, you know, as a state, I mean, when I talk about, you know, what we do as a public safety issue. I mean, not educating our new citizens, that's a public safety issue. And so there's definitely a lot of things we can do better for all patients to help. Not only let them know it's here, but that they need to stay in the program. So I think there's a lot of things we can do to fix it. And I think as we go through, I know we'll be having a strategy meeting. I'm just gonna kind of lead into the next item, is the agenda, right? I mean, I think if you guys have any agenda items you want to see, I know there are a couple items already that are gonna be on there for January. But we definitely have room. If there's anything particularly we would like, please reach out to Trevor, Abby, or myself, or Des, and we can make sure that you have time to present. If you need help getting information or getting things done, we do have the ability to have subcommittees. We set up a subcommittee that kind of does development way. But we're happy to get people involved and make these changes. Are there any other items you guys would like to see on the next month's agenda item?
Any public comment on the last agenda item?
I mean, we didn't really have any public comments, but I mean, if you'd like to add something.
I came late, so I didn't get to sign on that, so did you late sign on that?
No, I mean, I'm happy to open it up.
Okay.
So we'll open back up the last item and allow some public comment. Will you see online if there's any public comment? If you're online, can you raise your hand? Online share. Well.
Hello, everybody. Nara with Dragonfly. Awesome conversation. I just wanted to share, I came from the research and consulting world for 20 years. I worked in data analytics insights. So we're sitting on an incredible piece of data that we haven't begun to mine the data yet to understand. And the questions, these are all the right questions, right? We have the ability to identify very specific patient groups and populations and understand exactly why and who and where they're leaving. So that's a great basis of knowledge. Lots of the ideas are all great ideas. As I'm listening, they all ladder up to one fundamental thing. The card. We require a card. The only medicine required to get a card, right? That is the top of what we typically do in the research space of customer journey mapping, right? You follow your consumer through the entire path of purchase and identify the bottlenecks. And the card is the source of everything here, right? The source The card requires the doctor, the card requires regulation, requires an EVS system. Think about all of the costs that are directly associated with just the card. We literally turn people away because we can't let them check in because the EVS system doesn't work. The card is the catalyst for everything, right? And we can still have a medical program without a card, and all the suggestions at this table led up to that. We have doctors that are licensed professionals, right, that can administer any one of these single controlled substances, yet they don't want to because they don't want to go take a test, right? We have people that would love to get their card, but they're afraid for their employer finding out. They're afraid that their guns are going to be taken away because they have to register their name in a database and tell the whole world, I'm a cannabis user, while everybody else can live a normal life. This is where it starts, right? And short of going to an adult use that doesn't require a card, we can create a real medical program that works for people. I think what it really boils down to, thank you, can I have 10 seconds?
Yeah.
Is, do we have a program that we believe in and that we're proud of and we actually believe has efficacy? Because sometimes the rules that we make don't appear that way. It still seems like we're not bought in on what we're trying to do because we continue to make rules that put cannabis into this box. So thank you, guys.
Thank you, Derek. We did have, looks like some comments online, some of you have public comments, we'll go ahead and give them an opportunity to share. We'll start with BB. If you can go ahead and state your name and your affiliation for your comment, you have 2 minutes.
Yeah. Hi, can you hear me now?
Yeah.
Hi, yeah, my name is Brenner Burkholder. I'm just a member of the public, a patient. And I mean, I think that there are a lot of opinions to have about this in terms of what patients choose to do. And I moved here a few months ago. And I will say that I am one of the patients who has not yet participated. I won't go into much more details, but I mean, I think from what I've seen, just the level of quality is not there that is in other markets. I moved from Massachusetts, which has a recreational market. The quality is significantly higher, significantly lower cost, to the point that it does match the gray and black market. So I think a lot of this might, still just come down to economics, and what the policies are like. If we only have 8, I don't know how many exactly licensees there are, but if there's only 8 licensed production facilities or companies or whatever, there's just not going to be any push or competition for better pricing or better quality products because there's no competition. I mean, places like Maine, you can get a license as an individual for $500 and get your plant count up with a few $1,000s, and then have a vertically integrated company, but that's not even possible in Utah for anyone who cares about quality. So yeah, that's been a big sticking point for me is participating, is whether or not I, can even access consistently high quality medicine, and whether that just as cannabis is a batch product. So it's like if there's only one good batch every month or two, how do I know, and why would I spend my money on it if I can't even verify the quality or know that there's some level of consistency? So.
Thank you, Brenner. Go ahead and turn time over to the next individual. Looks like, let's see, Harrison Jones.
Can you guys hear me?
Yep.
Awesome. Yeah, my name's Harrison Jones. I'm a patient and also a part of the industry. Just wanted to make a couple of comments on a few things that I didn't see touched on. One being just expanding qualifying conditions. I think there are, other conditions that are not currently approved that would be beneficial from medical cannabis. And I think we could see that by taking data from the CUB program. Another would be just form factors of product that's allowed. Having other products that patients are used to in other medical markets. And then finally, just want to touch on just law enforcement education. Just as a patient and with family or interactions at pharmacies, I have been informed of, patients that have had, flour confiscated from them. during a traffic stop or, been informed by law enforcement that only approved forms of product is like lotion and topicals. And so I think, spending, some more focus on, educating law enforcement so they're properly educating the public will also help kind of remove some of the fear that patients and the public already have with cannabis. And I'll leave it with that.
Thank you very much.
Can we ask a follow-up question?
Yeah.
Yeah, if you like, Harrison, if you're still there, it looks like there's a couple questions.
Harrison, can we ask you to elaborate on what exact form factors you had in mind other than the topicals?
Is with the law enforcement education?
No, what
Or-
making other form factors available in the Utah market?
Yeah, that you were used to in other states. What are those products?
Yeah, like chocolates, having the fats and lipids help as a carrier with the cannabis oil for, just your body metabolizing it better. I was really sad to see the liquid suspensions leave in the taller sizes. It really helped with some of my gut issues that I had as they were nano and really helped quite a bit. And the smaller sizes just haven't done what the other size did. And so those are the ones off the top of my head, but
Thank you, that's useful information.
you bet.
Okay. All right, we will go ahead and close public comments. And we'll return back. Again, I think a lot of those items are things that we discussed, right? Obviously chocolate was a touching of my life that we were really excited for, and legislators took it a direction and a step further. So just so you know, we no longer have chocolate flavoring. Not just chocolate. So it went all the way against chocolate.
Well, you have choose, so.
We do have chews, so those are sort of like caramels and caffeines. Eventually those will be
I
released.
believe it's confections.
Confections.
Confection,
Yes.
which actually means donut. I'm just saying.
So we can have marijuana donuts.
That's what I've decided.
Okay.
Done for. That's chocolate. Give me, I do chocolate. Well,
On that note.
all right, I think, I appreciate you guys' time. We did go 3 minutes over my expected time, but we did schedule this meeting until 5. If you would like to stay another 42 minutes, you're welcome to. But if not, I'll take the last motion of the day, and that is to adjourn.
Motion to adjourn.
So it all passes, nobody.
Happy holidays.
Yes, you guys have a great Christmas.